question that I've seen a few times is what a B&B actually means. So now I appreciate that in different regions you've got different kind of jargon used. So in Bedford, a hostel in Bedford would be a supported accommodation. We don't use it for temporary accommodation, that term. But I know in other areas that's what they mean. But within the Homelessness Code of Guidance, there's a time limit on the length of time a family can stay in B&B. But then that leads to the kind of question: well, when does a B&B stop being a B&B? There's obviously kind of quite a grey area where actually accommodation, which for all intents and purposes looks and feels and sounds like a B&B, but technically it isn't. So councils are housing people for longer. So what in the Homelessness Code of Guidance, when it's talking about bed and breakfast, what is it? What exactly is there some kind of technical definition of that you can pinpoint?
If it's the most up-to-date one, it's paragraph 17.33 of the Code of Guidance. Housing authorities should therefore use B&B accommodation to discharge a duty to secure accommodation for applicants with family commitments only as a last resort, and then only for a maximum of 6 weeks, which, without deviating from what you asked me, will generally mean the councils will say, oh, you mean it's okay for 6 weeks? So that can be done, because they'll say, well, we're strapped, so it's always going to be last resort. But the actual regulation is the Homelessness Suitability of Accommodation England Order 2003, which was
and just for like the ignorant people like me, so if I understand that correctly, so you have these big acts of parliament, these big kind of laws that come in place, and then these statutory instruments are kind of like little additions that come along.
Yes, a statutory instrument will just add some detail, and what that says is what bed and breakfast is, which we haven't touched on. The actual legal definition is accommodation which has shared bathroom, kitchen, or toilet facilities. So it could be a hostel, because bed and breakfast sort of has a sort of non-legal context. If you think of people going to the seaside in the 50s or something, and we go to the same B&B every year in Blackpool or something. But and so you've got to have a sort of receptionist and breakfast in the morning. Whereas you don't. It basically covers hostel, which is what B&B is used for in the homelessness context. It's hostel accommodation.
And
sorry, go on.
Just saying, you mentioned like if the local authority owns the B&B.
That's the catch, which I don't know why they included that, but maybe it was because of sort of campaigning by local government organisations. But if the landlord of the accommodation which meets that description and would otherwise be bed and breakfast is the local authority, then it's not B&B.
And that means that local authorities can house families for longer than 6 weeks in such accommodation.
They can house them in that accommodation without falling foul of that rule, but it still raises the question of whether it's suitable or not.
Right.
And there may be reasons why it's unsuitable. And I haven't run this myself, but I'm tempted to that, although I did have some terrible run-ins with one London council which had converted an old folks home into temporary accommodation, which was essentially it fitted the description because it was shared facilities, and it was a really awful place. I mean, it was sort of ready to be knocked down, but they thought, well, just give it a last bit of use. But I could not challenge it, and partly because we couldn't actually show evidence that it was unsuitable. One of the things you could argue, if there were other reasons, was that if this was private accommodation, it would have long ago been unsuitable. Another thing, I'm actually issuing a judicial review, hopefully, if my pre-action letter doesn't work, although it hasn't done so far. And in this case, the council wrote back and said, sorry, we're not going to comply. But they put somebody in a B&B, and then they moved them out with the B&B after 6 weeks and put them in a travel lodge. However, the travel lodge has an ensuite bathroom and toilet.
Right, so
there's no kitchen facilities in the building. So they can say, well, this isn't B&B because there's no shared facilities. And so you're in a sort of ridiculous situation where somebody doesn't have any cooking facilities, and that's more suitable than somewhere where they did have shared cooking facilities. So we're going to challenge that and say that nobody could call accommodation without cooking facilities suitable. It's an out of London borough, that one, and they made the mistake. They're not actually arguing it. So hopefully we should win it, but I don't want to tempt fate. They're not arguing it on the basis of sort of technically this is suitable. They're saying, yeah, okay, it's not suitable, but we haven't got anything else. And I'm sort of thinking that they've opened, that's an open goal, that one, because the judges say, well, you know that you can't. If you decided that somebody's home, you know, that's in unsuitable accommodation and you're under a duty to provide suitable, then you can go out and buy it.